Thank you, Tony. We decided for our individual presentations we'd come to the podium and make it a little bit easier this time. We'll see if this works. Just a quick housekeeping matter. I had a number of people ask me for a business card in the hallway, and I ran out, but I failed to mention at the earlier panel, Freedom Guard is our organization, and our brochure, I think, is in your packet, and it has all of our contact info on the back. I had a number of pastors ask me if we would bring our legal seminar to your state, and we can do that, so just let us know. We mentioned in the earlier panel about how we're, in many ways, in uncharted waters. I mean, we are entering an era in our jurisprudence and our American legal history that is unprecedented in so many ways. The Supreme Court is making law from the bench, as we all know, and there are some really serious implications that come from all that. I also mentioned in the earlier panel that Americans United for the Separation of Church and State had a news conference at the National Press Club July 7, just a couple of weeks after the Supreme Court's opinion came down in Obergefell. And Barry Lynn was there, and I actually I pulled up the article during the last break so I could read you just this quick summary of the article. It says, Americans United announced Monday the launch of an aggressive initiative to combat any state or federal legislation or court ruling seeking to protect religious objectors of same-sex marriage from government consequence for living according to their religious convictions. And this is Barry Lynn's quote from the National Press Club just a few weeks ago. He says, those of us who value true equality, separation of church and state, equal treatment, and government policies free of sectarian bias do not intend to be passive. We are going on the offensive, he says. Now that's their clarion call to their side, and they didn't even need a clarion call because they're all, riled up right now and ready to come after you, right? So there's a defensive posture that we need to take. Some of the things, getting the bylaws ready. Peter's going to speak in a moment about combating some of the new SOGI ordinances that we'll talk about. But there's also some offensive measures that we can and should be taking on our individual state and local levels. So we shouldn't just wait around to have to defend against these things that are going to come. We should go out and take the ball and advance it down the field. So one of the things that we have recommended and tried and done, let me see the first slide if you guys will show me that. Just as just a case in point. During the last legislative session in Louisiana, it was my first term in the House in Louisiana, and we went in and brought a religious freedom bill. We called it the Louisiana Marriage and Conscience Act. You may have seen this because it was it's a good case study because it can tell you maybe some things to do, what not to do. Basically, this was introduced in in February of this year, well before the Supreme Court opinion came down. We anticipated what the court opinion would be. We expected it would be Justice Kennedy writing for a 5-justice majority, and we anticipated how bad it would be. And so this was sort of prospective legislation that says, look, when and if the Supreme Court makes this fateful decision for our country, we want to make sure in our jurisdiction, in our state, that the state will never be able to take adverse action against someone simply because they still believe in the Bible's definition of marriage. They believe in one man, one woman, natural marriage. The state should not be able to take any adverse action against them. What does that mean? Well, we said in our legislation that the state should never be able to take your tax-exempt status for your nonprofit organization or your church. Your professional license should not be in jeopardy. Your certifications, your private Christian schools accreditation, any other benefits from the state, all those things should be intact. The state should not be able to coerce you to violate your most fundamental right that you have, which is the right of conscience, hence the name of the bill. So we filed the bill. It should not have been controversial because it didn't say anything about licensing discrimination against people who have the other viewpoint or anything. But the left seized upon it immediately. And to be honest, in hindsight, they got out in front of us on it. I think we underestimated the furor on the other side. So they got out and they created a narrative that this would be state-sanctioned discrimination. That's the term you're going to hear over and over and over when we're defending religious freedom bills going forward. And it turned into quite a show. It took all the air out of the room in our legislative session. We had a $1.6 billion budget deficit, which should have been the big story. But the first half of the session was a discussion about, this oppressive religious freedom bill. By the way, just by way of further sort of disclosure for you who will help lead, hopefully, on some of these issues, and those in your congregation, particularly if you have elected officials in your congregation that you advise and that they seek your counsel. They need to know that if they stand up to stand for religious freedom in this arena, it is a pretty hostile climate. You figured that out. So I was actually getting ready for church Easter Sunday morning. I was straightening my tie, which I was watching Meet the Press, which, by the way, don't ever watch Meet the Press when you're getting ready for church anyway. It's a bad idea. But I had it on the background, and I was straightening my tie, and I looked just out of the corner of my eye, and I saw my name scroll up on the screen and in my bill, and they just were saying horrible things about me, and I'm doing my tie like, I'm not a bigot. Like, honey, And so then I went back down to Baton Rouge for the session, which was ongoing, and go to the next slide for me. This is what I was called on the front page of the Baton Rouge Advocate, a despicable bigot of the highest order, because of this bill that I just told you about, right? Thank you. It got worse from there. I can't quote to you from the stage some of the other things that were said. But the point is that we sort of knew. I mean, I've been in this arena, religious liberty litigation, for 15 years, so I knew kind of what to expect. But I've never seen the level of intensity, hostile fire that comes. I mean, we've battled abortion clinics and sexually oriented businesses and pornographers and the rest, but there's something really, really intense about this particular battle that you need to know, in full disclosure, the level, the attacks that you'll have. But at any rate, our bill, just by way of quick summary, our bill got mired in the process. It got committed to a House, the Civil Law Committee, which I serve on. There's 13 of us on the committee, and we lost it. There was only 2 votes in favor of moving it out of committee to bring it to the House floor, which was tragic. Thankfully, as Tony mentioned earlier, we have a God-fearing governor, Bobby Jindal, who's a dear friend of ours, and Bobby called me up to the office and said, no worries, I'm going to issue an executive order and do the same protections anyway. So the next slide is, go to the next slide. So he, on the same afternoon that we were defeated in committee, Bobby says, well, I'll do it this way, And he was fully within his authority to do that. There's a whole legal argument behind it. So we have this protection currently in Louisiana law, but it's by executive order. Obviously, a statute offers greater protection. And the reason I mention this as a case in point is this is exactly the kind of legislation that we're going to be recommending to each state over the coming months, because every state now has to have a bill, some statutory protection there, to determine how these issues are going to come down. If the Supreme Court says that there is a fundamental right to same-sex marriage, we have an inherent conflict. I thought Rick Scarborough's slide with the trains colliding is a perfect metaphor for what we're seeing. Because if you're going to have a fundamental right to same-sex marriage, what about the age-old, always recognized, inalienable, and fundamental right to religious freedom? Those two things are mutually exclusive pursuits in other countries where this has been tried, this social experiment. So every state has to wrestle with how they're going to balance those two freedoms. And we're going to have statutory protections like this, or else I fear that we're going to be steamrolled. There's more of this to come. July 14th in Louisiana, I'm using Louisiana as a case in point, an example, we got an opinion from the Louisiana Supreme Court Committee on Judicial Ethics, and it was an unsolicited opinion. This is the committee that governs all the judges and the justices of the peace in the state of Louisiana. And it was this sort of missive. They sent out an advisory opinion, and it said, don't even think about it. You Christian justices of the peace and state district court judges and appellate court judges, don't even think that you're not going to preside over same-sex marriages. If you try to claim a religious freedom exemption to this, you're going to be in violation of these 3 judicial canons of ethics, and effectively we'll pull your robe. I mean, they can't do that under the Constitution. And so we sent a letter out throughout the state to all the state officials and said, you don't have to abide by this. This cannot withstand constitutional scrutiny, at least we hope. And so we're looking for some courageous judges who will come in and stand as our plaintiffs so we can challenge the Louisiana Supreme Court's Committee on Ethics. So this is the kind of stuff that we're going to be facing. So there are state legislative initiatives that can be taken. There are also some things on a local level that we'll be putting out over the next few months as ideas. But you all are the sentinels. You all are on the front lines in leadership on these issues. And the old saying says, if the people will lead, the leaders will follow. Most, even committed Christian elected officials, are going to be very reluctant to lead on these issues because nobody wants to be called a despicable bigot of the highest order, right? They're going to need your encouragement. And I'm going to tell you, really, I mean, there was a time during this, I like to think of myself as a real tough culture warrior and all that, but it is difficult to withstand the withering fire. And I relied heavily on, prayer partners and pastors down there that were holding me up, and Tony Perkins was talking me through it. Don't give up, Mike, But it takes that level of commitment from you to see this thing through. And so we would encourage you to just be aware of that. If you have elected officials who are of like mind and are willing to be leaders on this thing and have the courage to do it, then we can help navigate them through that and advise them through the process. And what you're going to find here next, Peter's going to explain, is that some of this is happening now in the Congress as well, on the federal level, and that's a very encouraging development as well, and those folks need our encouragement and support as well. So 20 seconds left. I'll turn it over to Pete.
Well, thank you all for coming to this important event. I've been asked to talk to you about laws that outlaw discrimination in employment and public accommodations based on sexual orientation or gender identity. Sometimes for convenience, we combine the acronym SO for sexual orientation and GI for gender identity into a combined acronym of SOGI or SOGI to describe these laws. If you hear that acronym, you'll know what that means. Now, just to be clear, Congress has never passed such a law at the federal level, and fewer than half the states have passed them at the state level. However, even in a conservative state, like, say, Texas, some larger municipalities have adopted such laws at the local level. So no one is entirely safe from the threat that they pose. Now, let me review some key principles about non-discrimination laws before sharing why we are concerned about SOGI laws specifically. First of all, I want to point out we've been conditioned to think of discrimination, any kind of discrimination, as an unqualified social evil. However, remember, all of us discriminate all the time, including in the workplace and marketplace. To discriminate is merely to make distinctions between things and people. The only way for an employer not to discriminate in hiring, for example, would be to take the names of all the applicants for a job, put them in a hat, draw a name out at random, and give the job to that person. If they make the decision in any other manner, they are discriminating on some basis. So in that sense, discrimination is not only permissible, it is absolutely necessary in almost every walk of life. The question is not whether discrimination will take place. It will and it must. The only question is whether the particular grounds for discrimination are rational, that is, related to the requirements of the job, or irrational. The next question, however, is who decides which characteristics are relevant to a particular job? Should the government decide that? We as conservatives prefer to limit the role of government in dictating how private businesses or organizations should be run. So we believe the default position should be freedom. Freedom of willing buyers and willing sellers, or willing employers and willing employees, to contract with each other in a free market. Now, there are exceptions, but the burden must rest on government to justify interfering with that freedom, not on the private organization to justify being allowed to, quote-unquote, discriminate. We have this idea, this view of discrimination because of the civil rights movement of the last century, which sought to eliminate discrimination based on race. Those laws were passed to break the back of a system of discrimination that began with centuries of brutal slavery, followed by another century of discrimination that was not just culturally tolerated, but legally enforced. And in that case, the reason government declared that racial discrimination was virtually always irrational was because of the nature of race, something I call the 5 I's, the letter I. We ban racial discrimination because race is inborn, involuntary, you can't choose it, innocuous, it harms no one, and it is inborn, involuntary, immutable, innocuous, and in the Constitution. None of these 5 criteria, however, apply to discrimination based on a person's choice to engage in sexual acts with someone of the same sex, or their choice to dress and present themselves as the opposite of their biological sex. So, we oppose these SOGI laws because they increase government interference in private decisions, and because these characteristics, which are primarily behavioral, are not comparable to the characteristics usually protected. However, there are other reasons to be concerned about these laws. First of all, they are not morally neutral. Some people may rationalize their support saying, you're still free to hold your beliefs, but this is just to make sure that everybody's treated equally in the public square. Don't believe it. Was the Civil Rights Act of 1964 morally neutral with respect to racism? Of course not. The moral message of the civil rights laws of the 60s was, you may hold your racist views in private, but the full force of the federal government is coming down in favor of the opposite moral judgment, in favor of a judgment that the races are fully equal in every way. Now, it's ironic that it's usually conservatives who are told that you can't legislate morality. But SOGI laws themselves legislate morality, or rather legislate immorality, since they embrace the values of the sexual revolution. They declare, as a matter of public policy, that there is no moral difference between homosexual conduct and heterosexual relations between a husband and wife. And they declare, as a matter of official public policy, that it is human beings and not God who decides whether someone is male or female. Any Christian who claims to believe and proclaim biblical standards of human sexuality, but who at the same time supports SOGI laws, is guilty of a moral, legal, and logical contradiction. Now, that's the larger issue of principle, but there are also very practical concerns about the threats to religious liberty. Sometimes these laws contain religious exemptions of various types. But you need to know that in the current climate, homosexual activists are becoming less conciliatory about religious exemptions, not more so. For example, the newest comprehensive SOGI bill introduced in Congress last month, known as the Equality Act, unlike earlier bills at the federal level, the Equality Act contains no religious exemption, none. Now, laws in other states and various court rulings have varied in their treatment of religion. The Supreme Court has upheld a ministerial exception, so churches will not be forced to hire a gay or transgender pastor. Your position is the best protected, but almost any other position might be vulnerable. If churches are exempted, other religious nonprofits may not be. And even if the law has a strong exemption for churches and religious nonprofits, they virtually never give exemptions for any kind of profit-making businesses, meaning that Christian bookstores, publishers, and radio stations are subject to these provisions. This issue, of course, has been well publicized in these cases involving the wedding industry, in which Christian photographers, florists, and bakers have been sued for declining to participate in the celebration of same-sex weddings or commitment ceremonies. Now, some people have suggested a sort of grand compromise whereby homosexuals and transgender people are granted protected status under civil rights laws, while religious liberty protections are codified at the same time. This approach has now been endorsed by the Mormon Church and subsequently adopted by the Utah legislature. But FRC opposed this approach for 3 key reasons. First, it represents a moral and legal contradiction, as I mentioned. Second, the free exercise of religion is not something to be negotiated away or negotiated for in pieces. It is a constitutional right, our first freedom, and must be indivisible. Finally, it's a compromise that is unlikely to hold. The real goal of the homosexual movement is not peace, it is total victory. The creation of a world in which no one, ever, anywhere, says that it is morally wrong to engage in sexual acts with a person of the same sex. Now, finally, let me emphasize, we must treat all people with dignity, respect, and love, including people with same-sex attractions. We should welcome them to join us in worship at our churches. After all, we're better for them to hear the gospel and come to a saving faith in Jesus Christ. But we cannot compromise our moral principles or our religious liberty, and therefore we must oppose sexual orientation and gender identity laws at every level of government. Thank you.
I'm gonna sit right here if that's okay with y'all. I have 10 minutes to discuss some really important federal legislation. I'm gonna touch on, in some respects, what Mike was talking about, as well as what Peter was talking about. So I'm from Georgia, but I'm gonna try and talk a little bit fast this morning. So if y'all will stick with me. The first thing I wanted to do is address what Peter was talking about, which is the Equality Act. And Peter mentioned some really important facts about the Equality Act. One other thing I wanted to say is not only does the Equality Act not provide protections based on religion, but it also strips protections that we already have in federal law based on religion through what's called RFRA. So that's an important piece of legislation that you guys should keep in mind. The other thing that I wanted to start out talking about is the federal version of what Mike is planning on introducing in multiple states. And that's FADA, the First Amendment Defense Act. And the First Amendment Defense Act does exactly what Peter was talking about, which is it protects our first freedom, our freedom of religion. At the oral argument in the Obergefell case, Justice Alito asked Solicitor General Verrilli, what about Christian universities that refuse to acknowledge that marriage is anything other than the union of a man and a woman? What about them? Will they lose their tax-exempt status? And the Solicitor General's response is, it's going to be an issue. It's going to be an issue. And so we're taking the Solicitor General's response very seriously. And so FRC is pushing for the First Amendment Defense Act, which would actually serve to protect folks, to protect individuals and entities at the federal level from being discriminated against by the federal government. So we've had HHS ask abstinence organizations, so what is your position on marriage? And so that concerns us, and it concerns us that the Kleins have been discriminated against in Oregon, and Baronelle Stutzman in Oregon, and Kim Davis is one of the judges that Mike was referencing that he's looking for in Louisiana. She's in Kentucky, and she doesn't want to issue marriage licenses to same-sex couples. And so our concern is that what we're seeing on the state level, we're also going to start seeing that kind of discrimination on the federal level as federal agencies start to push same-sex marriage more forcefully. And so the First Amendment Defense Act is set up. It's been introduced in both houses of Congress to combat federal discrimination against individuals and entities in regards to the provision of loans and grants and scholarships. We don't think that person should lose the Pell Grant because he attends a university that believes marriage is the union of one man and one woman. And so there are lots of types of ways that the federal government is engaged with individuals and entities, and so this would prevent the federal government from discriminating based on marriage or a person's view that marriage is the union of one man and one woman. And there are a couple other bills that I wanted to talk to you about, one of which Tony already mentioned, which is defunding Planned Parenthood. I'm sure that so many of you have seen these videos from the Center for Medical Progress that have just really depicted the horrors of abortion, the horrors that we know and have known for quite some time. Agree or disagree with John Piper's theological views. I love what he said a couple years ago, and that we've always known that these are lives, that these are unborn human lives, and these videos have depicted that in a graphic way that prevents people from really turning away from these facts now, right? So there are, before the Senate went on recess, they've been out for most of August and are going to come back after Labor Day. The Senate voted on a complete defund of Planned Parenthood bill, and it failed by only 5 votes on a procedural vote. And so we're hopeful that when the Senate and the House come back, that we'll actually get to vote on that again, that the House will introduce it as maybe a rider on must-pass legislation. The Congress is only in session for about 10 legislative days in September. So we have a limited amount of time, but we're hopeful that we can attach at least a 1-year moratorium on funding for Planned Parenthood. I heard that someone mentioned this in an earlier breakout session, but Planned Parenthood gets $528 million of government funding a year. A nonprofit that gets $528 million a year, they've received a total of $1.3 billion in government funding. And now we know exactly what they're doing with that. They're charging women for these abortions, and then they're charging these organizations that want unborn baby body parts. And it's just atrocious, and it needs to stop. And so we would love to have you guys and have the folks in your pews to contact your legislators and let them know how important it is for Planned Parenthood to be defunded, especially in the wake of these CMP videos that have been released, and especially when basically what we're asking for is 1 year of defunding while these investigations ensue, and we're able to have Congress look into more specifically what Planned Parenthood is doing and what they're using our tax dollars for. And the next item of legislation, I only have 2.5 minutes left, is closely related, and that's the Pain Capable bill, which actually, thankfully, was passed in the House back in May. And what the Pain Capable bill is basically after 20 weeks, really a little bit before 20 weeks of gestation, babies in the womb are ready and able to feel pain. And so we think that they should be protected even at conception, but at the very least, as they can feel pain in the abortion procedure. And so basically what the Pain Capable bill does, and it's been introduced in the House and passed in the House and introduced in the Senate by Senator Graham, and we're hoping for a vote on this in the fall as well. But basically it says, physician, before you perform an abortion, you must find out how old that unborn baby is. You must find out that gestational age. And then it says, if that baby is 20 weeks old, and if that unborn baby can feel pain, you're not allowed to abort it. You're not allowed to take that baby's life. And so we're so thankful that we've seen a vote on that already in the House. And we're really hoping, and we'd love the support of you all, of your churches, of the folks that are sitting in your pews. We'd love to hear you guys talking about it in the pulpits, that this type of legislation is what we really need to see passed at the federal level. We need to see protection for life at every stage of development, but especially after these unborn babies are already scientifically able to feel pain. And in fact, I wanted to let you guys know that we have actually quite a few documents in your registration packets. One of those is on fetal development and fetal pain. Another is a one-pager on the First Amendment Defense Act if you're looking for more specific information about that. We have the letter that we provided to Senator Graham and other senators requesting co-sponsorship of the Pain Capable bill in Senate. We have a couple of other documents as well as the Family Policy Council's sheets. So I know that we have, I think they said more than 30 states represented here today, which is awesome. And we have FPCs in each state. And so within your registration packet is a list of the FPCs. And we really encourage you guys to get involved in those to remain up to date on what's going on in your state on a local level. And then also, you know, we can keep you up to date on the federal level. Just be signing up for FRC alerts if you aren't already. And then I think Tony already mentioned that we have a petition on the defund of Planned Parenthood, and we would love for you guys to get engaged in that way by sending that petition as well. So we're excited that there are a few action items for you all this morning, just in how you can get engaged on the state and then also the federal level on these. At least we have these three main pieces of legislation that I wanted to touch on today, but of course there are others as well.
All right, let's thank our panel. And now, same guidelines. If you have a question, we have 2 microphones that are going to be circulating in the room as to how you can be involved in supporting these legislative initiatives, or maybe there's things at the local level that you're considering. And so while we have our panel of distinguished experts here, and Peter, we can, and a little inside joke there with Peter. Peter's a great guy. Peter, by the way, is a former pastor as well with the Northern Baptist, or American Baptist.
Yeah, right. Well, yes.
not Southern.
But
He
now
speak-
I
he
attend a
speaks too
Southern
fast.
Baptist church. So
Yeah.
there you go.
Anyway, he's a great member. We have, by the way, that's where pastors go, is to FRC. We have, our staff is filled with pastors because we believe that connection between the cultural mandate and the Great Commission is so strong. But any questions we have? But here we go, right in the back.
My name's David Rose. I'm pastor at First Baptist in Winsboro, Texas. Little community, about 3,000, small county. Our county judge is a good friend of mine, former member of my church, attends another church, strong believer. One other employee in that office who's also a believer. And she called me on June 27th and said, "What do I do?" And so we talked, and I said, you know, there are going to be people say, you're an agent of the state, you got to do what the state says. She said, "But I don't want to." And others would say, "Well, have somebody else in the office do it." Well, there's just one other person, and she doesn't either. What counsel can we give? I know you had mentioned earlier, said don't give up, you don't have to do this. What can I do as a pastor? Because I've got other friends who are in the legal world and some judges as well that are facing this. What can we tell them? How can we support them?
Well, Texas is one of the states where early on the Attorney General's office issued an advisory opinion in an offensive manner on our side and said, you still have religious freedom, you'll not be forced to do that. So at least, last time I checked, at least in Texas anyway, those clerks and those justices of the peace and all the rest, they at least have a legal argument that the AG's office is on the side of religious freedom. In other states, not so much. And so, but we're not going to give in our First Amendment rights, our fundamental freedoms, just because even a group of judges says that, well, they implied that this might be the new regime. We're going to have to defend every single inch of that ground. And so what we need is, we need pastors to encourage the people who God has raised up to these offices to stand strong, because we can defend them, and we're very confident, our legal organizations are confident that we can win these cases, and we have to carve out a space for religious freedom, or else all hope is literally lost for the republic. I mean, I don't want to overstate this, but this is a pretty big battle. And if we give in on any of those voluntarily, then we're surrendering ground that we could and should have fought for. So, I mean, the short answer is tell her to stand strong, and if she needs specific legal counsel on it, our organization, Freedom Guard, Kelly Shackelford's group, ADF, would be happy to help and kind of counsel her through step by step on how to do that. There needs to be a religious accommodation that we talked about earlier, even in the county clerk's offices, even amongst justices of the peace and the rest, and I think we can defend those.
Denny Stahl, Calvary Chapel, Grants Pass, Oregon. First, my apologies. Our junior senator from Oregon, Jeff Merkley, is the poster child for the Equality Act, the sponsor of the bill. And that raises a question I'd like to address, especially to you, Mike. It's wonderful that we have prospective legislation that can turn the tide. You, of course, are familiar with Aaron and Melissa Klein. They lost their business, fined $135,000. And when that complaint was brought by the lesbian couple, it wasn't before a jury of their peers. It was before the Bureau of Labor and Industry in Oregon. So one judge listened to the entire testimony and deposed people and so forth, then determined what the fine would be. And then one man, a nonpartisan office holder, Brad Avakian, had the opportunity to either void that decision, increase the fine, but he agreed that it should be $135,000. Been speaking with Anna Harmon, who's one of the attorneys who's working in that case. And thanks to the Heritage Council and their ability to investigate, we believe there's collusion between Avakian's office, the Bureau of Labor Industry, and the Basic Rights Oregon group, which championed this punishment. And that's exactly the verbiage that they use, this punishment of this couple. But I wanted to ask you a specific question. As I understand the case, there were already laws in Oregon at a time when same-sex marriage was not legal in Oregon. In fact, we had amended the Constitution in 2004 to make sure that marriage was defined in Oregon as between one man and one woman. There was something similar to the Equality, the Non-Discrimination Act in Oregon law that Avakian quoted as he levied this fine upon them. Would you just comment about how can we overcome the infrastructure when those kinds of laws are on the book?
Yeah, I mean, I'll pitch this to Peter in a minute. I mean, basically that was a SOGI ordinance, a sexual orientation and gender identity ordinance, and that state was one of the leaders on it, and they provided a model that has been adopted by, there's scores of cities now around the country. New Orleans has one in my state, Shreveport, my hometown. And what it basically says is that they were done before the Obergefell decision, and it said that you can't discriminate against someone based upon their sexual orientation, and it's defined in any number of ways. And basically it was an anti-religious freedom measure, because the only people who had objections normally were Bible-believing Christians, you know. So it says religious freedom has to take a back seat to these claims by these folks. But, you know, Peter had done a lot of work on that. Yeah.
Well, yeah, what you said was a point that I had in my talk and left out for the sake of time, but that a lot of these cases, we have tended to associate them in the cultural context with the redefinition of marriage. But from a legal perspective, they're rooted specifically in the existence of these SOGI laws, not in the definition of marriage. So as you said, the Kleins were prosecuted under, even while your state had a marriage amendment defining marriage as the union of a man and a woman. So it is these. Now, that means, though, that in the current context, where the U.S. Supreme Court has redefined marriage in all 50 states, we can still fight against these SOGI laws, and it would still help to be protected against them. Other point you made, though, and this is something for when you're analyzing legislation or and so forth, is your first point about look at the enforcement mechanism. And if it's enforced by an administrative agency rather than by a court, and if it's enforced by something that's called a human rights commission, whether at the local level or state level or something, you're probably in trouble, because there's going to be an inherent bias, and you won't have the same kind of due process protections that you would have in a court. So we need to be concerned not only about the content of the non-discrimination provisions, but also by the enforcement mechanisms, which can be troubling as well.
I'm going to piggyback off of that just a little bit, just to let you guys know that whereas these SOGIs were the primary mechanism of going about providing sexual orientation and gender identity protections, we recently learned that actually the EEOC in the Equal Employment Opportunity Commission, which is the commission that investigates employers for violation of discrimination claims, we recently learned that they have handed down a policy guide that essentially says that now sex, which has always, for ages been protected in the Civil Rights Act and various other non-discrimination clauses, is actually going to include sexual orientation and gender identity. So whereas Peter's right that previously the SOGIs were the primary mechanism, and then you had local boards and bureaus that were the enforcers. Now the EEOC is going to be doing that, and we've seen them do that in Minnesota and actually won a court case. And so that's kind of the new trend. It's only one case, and then they've settled in Lakeland, Florida. They settled a case outside of court, essentially on the same grounds where they were going after an employer for a gender identity discrimination claim under the term sex, which has historically not been interpreted to include gender identity and sexual orientation, and that it was a Lakeland eye clinic. That eye clinic actually settled with the EEOC, and then they won in Minnesota. So based on this policy guide, they've been invigorated, and they feel like they can, go after businesses under that guise now. So we're looking at that and watching for that a little bit more as well.
Now that goes back in part to the culture impact teams in your church that would be monitoring state activity as well as your local government that may be adopting these SOGI ordinances. As been discussed earlier, they slip them in under under darkness. In fact, it was in Houston, Texas. Pastor Steve Riggle will be speaking a little bit later. There's Pastor Steve. This has been a huge issue there where they've forced this on the community, and now they've been fighting, pushing it back, look like they're going to overturn it. Every city does not have these yet, and it is important that we stay on top of this to keep those out while we're still working to get the religious freedom protections through FADA and the other measures. Back here in the back.
My question centers on the fact that as egregious as it is to understand that we have a law now, quote, unquote, a law that initiates same-sex marriage as a civil right, What is exceedingly more egregious to me than that is that 5 lawyers presume to impose their will upon 50 sovereign states and the American people in an unjust law. Is there a growing move and discussion, examination of the principles known as interposition or nullification, whereby states simply say that we're nullifying this law, we will not obey that? Is there any thought in that area?
We'll let Tony answer that one. No.
Well, go ahead.
No.
Well, I'd say there's a lot of prayer in that area and a lot of thought. I don't know if there's a lot of action. The problem is, really the only way to overturn a bad opinion from the Supreme Court is to enact a constitutional amendment or to do a statutory measure like we did with the Religious Freedom Restoration Act, which was in response to a bad Supreme Court opinion many years ago, trying to say that the government can't infringe upon your religious freedom without a compelling interest, and they do it in the least restrictive means. I think to date, 25 states have their own RFRAs, and that's something, if your state doesn't have that, that's something that ought to be discussed. But ultimately, it's a constitutional amendment process, which, requires 2/3 of the Congress and 3/4 of the states to agree. Or the Congress has the constitutional authority to limit the jurisdiction of the Supreme Court in certain areas. They could say, theoretically, if their political will was there, if we pushed the issue, the Congress could say, you know what, we don't want the federal courts to be able to decide the issue of marriage. That is reserved to the people. It always has been since time immemorial, and it should stay that way. You usurp their authority, and so we're going to take it away from you. But reality is the political will there to do that? I mean, sadly, I don't think so. So we're left to sort of fight for these inches of ground that are left, and maybe, elections do have consequences. New president probably will appoint at least 2 Supreme Court justices, maybe 3 or more. And that could be the thing that changes the tide. The Supreme Court has reversed itself before, as you know. Slavery and is an example. So all hope is not lost. We know how the book ends, and there's always a reason for hope. 1 Peter 3:15 says be prepared to give an answer for that. But we know that these are difficult days. No other way to say it.
To the practical application of that, I do think what happens within 5 years, if this is not overturned within 5 years or so, it's going to be locked in. And the quickest way to do that is in this upcoming election. I'll give you a very clear example of what you should be considering in presidential candidates. I was at the debate in Cleveland, and one of the candidates, the governor of Ohio, was asked about same-sex marriage, and he said, well, the court has decided this, and it's a done deal. Well, wrong answer. The court is not the final word of what happens in our republic. 5 judges or 5 lawyers in black robes are not the final word of where America is headed. And so I did a number of interviews afterwards, and I said, this man is not qualified to be president of the United States because he doesn't understand civics. So we can see, Mike is absolutely right, we have some justices that are hanging on to oxygen tanks that are on the Supreme Court that could be replaced at any time. And the next president will have an opportunity to appoint at least 2, maybe 3 Supreme Court justices. Elections have consequences. I said yesterday, the future of America is not dependent solely upon election, but it is a key part of what we must do. And so this is something that you should be looking at in every presidential candidate. And there are some that have not only spoken with clarity to it, but have laid out a clear path forward to return marriage to what it has been and what it should be in this country. So I'll get off my soapbox. All right, next.
I want to know, why are we not, or maybe is there a reason why we cannot? Well, let me back up a little bit. We've got bureaucrats, basically judge and jury, and you're out. Why are we not fighting these on the grounds that I have a right to trial by jury, and I want a trial by jury for these cases?
Well, we do on some of those cases. I mean, when you're talking about the SOGI ordinances, these are set up by local ordinances, local laws. And so what they do is they set up one of these little tribunals of appointed persons. So it's like the mayor gets to appoint who's on the Human Rights Committee or whatever they call it on the local level. And they are bureaucrats. They're appointed by whoever is in power. And typically when they're going to look after, who's going to enforce our sexual orientation ordinance, of course, you have willing volunteers of all these, activists that support homosexual behavior. So all stand there going like this, and they go, yeah, you. And so there are no evangelicals on those committees, I can assure you, right? So, I mean, the problem is you go before that tribunal, and your fate's already decided before you show up. And then they're given the authority to fine you and drag you out through the court of public opinion. And it is a violation of due process in many ways, which is why we do have some hope that we can challenge these. I mean, all the cases that you heard about, except for one, was mentioned this morning, is a final decision. The rest are on appeal. And so we've not given up on those. I mean, I think we can still win for the bakers and the florists, but it is a hard-fought battle. And yeah.
I wanted to mention one other thing. There is a legislative approach at the state level that has been taken in a couple of states with respect to these local ordinances. And it's the passage of something called an Intrastate Commerce Act, which requires that local governments within that state have only the same protected categories in their non-discrimination laws that exist in state law. Now it's important, it's worded that way. Back in the 1990s in Colorado, they passed a state constitutional amendment that just basically said you can't pass special laws to protect homosexuals. And that was struck down by the Supreme Court, because they said it singled out homosexuals. So this is actually not singling out any one group, one category of protection. It's saying we want to have uniformity across our state for the sake of businesses being able to know what the expectations are and to know that the expectations are going to be uniform across the state. We will have one standard, and that will be set by the state. But those do have the effect of overturning some of these local ordinances. So that's been done in Tennessee and Arkansas, I think, and that's an approach that can be done at the state level. It's one of the few areas where really we can go on the offensive legislatively against these type of things.
There are also, within constitutional law, requirements that you kind of have exhausted your administrative remedies prior to getting to court. And so that's kind of why a lot of times we have to go through these administrations and bureaus and things like that before we actually get to a court of law, because the court's going to say, well, did you exhaust your administrative remedies? And if the answer is no, they're going to say, actually, you need to go and try that. And you need to go back through the process of going through the bureau or whatever the administrative organization is. And of course, like Mike said, those are loaded down with liberals or people that are going to be in favor. So I'm not sure if that answers your question, but I just wanted to throw that out there.
Yeah, it's important in those cases where you have to go through the administrative, before the administrative law judges, that you do have eventually the remedy of going into the courts. However, the challenge is the cost. The challenge is the emotional toll that this takes on the individuals, like the Kleins. We've walked the Kleins through this entire process. They've lost their business. They've been fined $135,000. They've been put up, a picture of them as if they were wanted criminals. They have five children that they homeschool. I mean, this takes an emotional toll and a spiritual battle that's raging even within their own homes. And we're going to talk about this in a moment in one of our upcoming panels of how you as pastors can stand with them. It's easy for us to theoretically say, well, if they stand, we're for them. How are you for them? Yeah. And we're going to talk about that. But it's also good to know, and you need to communicate to your folks, stand firm. We'll stand with you. You've got the law firms, the public interest law firms that will stand with you as well. We must stand and defend these fundamental freedoms lest we lose them for everyone. We have one final question, and we're going to have to move to our next panel. Our next question, yes.
Dr. Dale Burrows, Biblical Heritage Institute, and Dr. Henry Brandt Ministries. I'm from Florida, Tallahassee. I don't know why the Lord has worked this out, but the second my two representatives are number 2 in each the House and the Senate. and I have both their ears. And I've been working more through their heart, and both of them are Christians, and both of them are growing, but both of them are under major, major attack right now. Do you know very much about what's going on in Tallahassee and how I can be an encouragement to them to do right? Because up to this point, the Lord has used me to build them up with their heart. But I know I'm going to have to transition into, now, what do you do?
It's a good question. I know there are lots of skirmishes in Tallahassee. I don't know all the fine points, but we could talk about it afterwards. But in general, it's a great question, and I'm glad you asked it, because I did want to end on that or say it before we were done. As an elected official, Tony was a former elected official in Louisiana. He can tell you as well. It means so much. I mean, if you're an evangelical, Bible-believing Christian, and you're in elected office right now, it is a very difficult time to serve. If you're going to stand for our issues, and it means everything for people like you to just pick up the phone and call, send an email. I mean, as trite as it sounds, that means a lot to me when I'm taking fiery arrows from every direction, to know that. And you know, Mark Sturmer was in the back here. I saw Pastor Mark. He lives in the Baton Rouge area. He would come down to the Capitol, and I'd see him in the hallway, and he's a former Marine. Well, he's a current Marine. You're never a former Marine. I get it. But he would look at me like, I got you, man. You know, and that as silly as it sounds, that means a lot to know that, you know, the body, we stand together, and God, you know, Scripture's very specific about praying for those that God, you know, lifts up and puts in positions of authority. But I think your role is more important than the person pulling the lever, because you're the spiritual front of this battle, and you've got to encourage those, because it's going to take tremendous courage in the days ahead to advance the issues that we care about and that we advocate. And so we need you, and it's a prayer covering, but it's also just that word of encouragement. So thank you for saying that. I know that means a lot to them, and it means a lot to me.
Let's thank our panel. Mandi Ancalle, Peter Sprigg, Mike Johnson,